Somebody noticed that there was nothing in the syllabus for Thursday. Proves that I'm not infallible. I don't know how many times I looked at it, but I didn't notice it. Anyway, we definitely have class Thursday, and it's an important one because we'll still be talking about the Pentagon Papers case, and the reading is the same section 3 of the reader reading. Today, Near versus Minnesota, starting on the Pentagon Papers, and then we'll finish up with WikiLeaks next Tuesday. In 20 minutes, the Ninth Circuit Court of Appeals is going to decide the Proposition 8 same-sex marriage case. That'll be the big news of the day for the 14th Amendment, because it's a 14th Amendment case, but not, obviously, a First Amendment case. You'll remember the Sedition Act. I hope you never forget it. American law learned its lesson from the unfortunate episode involving the Sedition Act of 1798. And you remember that it was a very serious infringement of our citizens' right to criticize government, specifically the President or either House of Congress. Notably, the drafters of the Sedition Act left out the Vice President. The Vice President was fair game. Could be criticized. The Vice President, of course, was Thomas Jefferson of the Republican Party, not a member of the Federalist Party, and the Federalists, then in power, wanted to make sure that the Republican press did not sabotage the fragile new American state, so they enacted the Sedition Act, but it would have allowed criticism of Jefferson. That law was intimidating, to say the least. It made it a crime to say anything false, scandalous, malicious about the President or either House of Congress, and it was deterred, undoubtedly, speech of that kind, but it wasn't the most serious kind of First Amendment, a restriction on First Amendment rights. The most serious is a prior restraint, which means an order by the government, an action by the government that prevents you from speaking in advance. Think of censorship. And the concept of prior restraint was one that was familiar to the drafters of the First Amendment, the framers of the Constitution, from their colonial days, because in England, up until 1694, less than a century before the First Amendment, the press, consisting of printers, the press was censored by the Crown in England, and a printer had to get permission from the royal authorities in order to publish. And the printers would submit their proposed broadsheet or whatever it is they wanted to publish to the king's censor, and then the censor would say, okay, or not okay, you can't publish that. But that was the classic kind of prior restraint, where government reviews what it is that you want to publish before you publish and says, yes, you can go ahead, gives you permission, or no, you can't do that. That's the classic kind of prior restraint that was known to the framers of the Constitution, and it's the most dangerous kind of restriction on speech. It stops speech before it's spoken, and, importantly, before anyone can know for sure whether the speech will cause any harm. It involves, that is, imposing a prior restraint on speech, involves a prediction by the decider of whether harm will result from the speech that's in question. The first case that ever landed in the Supreme Court with regard to prior restraint, Congress didn't attempt any, certainly in the 18th century or in the 19th century, and there were no cases of prior restraint. It was assumed that prior restraints would violate the First Amendment, at least in general. That assumption was based in part on the writings of Sir William Blackstone, an English treatise writer from the 18th century, who attempted to sort of summarize the common law of England as of that point. And it was after England had abandoned this prior restraint censorship apparatus at the end of the previous century when Blackstone wrote that freedom of speech consisted in being able to publish one's own thoughts without restraint by government, although you would be responsible afterwards if what you said actually was illegal, libel, for example. You could be punished after the fact. And the framers of the First Amendment knew about Blackstone, were entirely familiar with what he said the law of England was, and the assumption was prior restraints are, they weren't thinking much about prior restraints because they were pretty sure that government would not attempt to impose any. So the very first case that came to the Supreme Court was Near versus Minnesota in 1931, and there's a good story about Jane Near and his struggles in Minnesota. He published a weekly newspaper, which was basically a scandal sheet. It was called the Saturday Review. There's a wonderful book about the Near case that you ought to read over the summer. Read it in your spare time now. It's a quick read, easy, accessible, written by Fred Friendly, who was head of CBS News for a long time, then went to Columbia and taught about the First Amendment there. And Jane Near's story is that he was a borderline extortionist who had been in the newspaper business up in the iron ore fields, or whatever they are, hills in northern Minnesota, and ran sort of newspapers with others that would expose scandals. The local banker had been caught at Susie Q's bordello the night before, and so on. And then they would go into other businesses and say, you know, we've got this on you. We know what you've been up to. It's not the kind of story that we would like to run, and we don't want to embarrass anybody in the community. So, you know, if you can assure us that you will advertise in the paper every week for the next year, we'll forget about this story. That was the kind of business that J. Muir and his associates were running. Then he moved to the Twin Cities, Minneapolis, St. Paul, and started the Saturday Review, which was a weekly newspaper that was of the same ilk. That is, it exposed local scandals, and it savagely attacked the entire establishment of the Twin Cities, the mayor, the chief of police, the county attorney, and so on. And it was irresponsible journalism, no doubt about that. And it was virulently anti-Semitic, as you see from the excerpt about one of his rants about the Jew gangsters who run the Twin Cities. Well, at some point in the mid-20s, the Minnesota legislature got fed up with this brand of journalism and passed a law, the American way. There ought to be a law, familiarly known as the Minnesota Gag Law, aimed at newspapers of this kind. And it involved a very innovative legislative technique that I don't think anybody had thought of before. Section 1 of the law says any person who's engaged in the business of regularly or customarily producing, publishing, A, an obscene, lewd, or lascivious newspaper, or B, and this is the one that was applied to J. Muir, a malicious, scandalous, and defamatory newspaper, is guilty of a nuisance, the law said, and may be enjoined, that is, subjected to a court order from further publication of this nuisance, which is the newspaper. Well, the concept of nuisance was well known to the common law. Nuisances might be a dump, for example. People started dumping their garbage in some residential neighborhood, and it smelled foul and it attracted rats and so on. Or a saloon that was open late and was noisy and disturbed the peace, and people couldn't sleep because there was so much noise and commotion around the saloon. Those kinds of things at common law might be deemed to be nuisances. And the way that the law dealt with a nuisance was to abate the nuisance by getting a court order saying, stop doing that. Well, the Minnesota legislature decided to apply the concept of nuisance to newspapers, to the newspapers that they viewed as nuisances, disturbing their tranquility. And so they passed this law, and after J. Muir had published 9 issues of the Saturday Review, the local authorities, the county attorney from Minneapolis, sued Muir, not a criminal case, he sued him civilly, trying to get an injunction to abate the nuisance. And the evidence submitted by the state was the 9 issues that he had published. That was it. That's all he had to prove. And the judge was able to conclude from the content of the 9 issues that the newspaper was malicious, scandalous, and defamatory. And the judge issued a preliminary injunction against further publication of the Saturday Review. And then the case went to trial, where the evidence was simply the 9 published issues, and J. Muir didn't put on any testimony or evidence in his defense. He just made a legal argument that his newspaper and his publication of the newspaper was protected by the First Amendment to the United States Constitution, as made applicable to the state of Minnesota by the Due Process Clause of the 14th Amendment. The judge, at the conclusion of the trial, issued a permanent injunction shutting down the Saturday Review, and J. Muir was somehow able to, I guess the case had attracted the attention of Colonel Robert McCormick, the publisher of the Chicago Tribune, enormously wealthy, powerful man, certainly the most important newspaper in the Midwest, and McCormick was alarmed that a state could put a newspaper out of business, and lent his high-powered corporate law firm that represented the Chicago Tribune to represent J. Muir and take the case to the United States Supreme Court. And that's where it went in 1931. The law, I guess it was 1925 law, was pretty simple and straightforward. It did provide for a defense if the truth were published, so long as the truth was published with good motives. Notice that Muir did not attempt to make that defense, so one might conclude that what he was publishing actually was false. Though there was no finding and there was no necessity for the judge to find that any of the material that he published was false. It was enough if it was malicious, scandalous, and defamatory. Well, when the case was decided by the Supreme Court, the opinion was written by then Chief Justice Charles Evans Hughes. And he quickly disposed of the threshold issue of whether First Amendment rules apply to the states. This is real familiar territory for you now, saying that the freedom of speech and the press is within the liberty safeguarded by the Due Process Clause of the 14th Amendment. Citing, of course, the Gitlow case, which the court had decided 6 years before, in 1925. And then going to the merits of whether this law violated the First Amendment, Chief Justice Hughes looked primarily to the practical effect of having this law on the books. The law didn't require proof that anything false had been published, and the trial court had been able to find malice, defamatory meaning, and scandalousness simply by looking at what Muir had published. The idea of the law was not to compensate somebody who was maliciously and scandalously attacked in the newspaper, but rather to shut down the newspaper. And that opens up the question of prior restraint, because the practical consequence of the judge's order saying, enjoining publication, you may not publish the Saturday Review or anything like that, in substance, the practical effect of that was to put the newspaper out of business. Sure, J. Muir could have reformed himself, could have decided that instead of covering city politics, he would cover baseball or gardening, or something innocuous, non-political. But if he was going to cover politics, which was what he was up to, then he was under the gun and under the threat of being held in contempt of court if he published something that the judge might consider a violation of the judge's order. And Chief Justice Hughes, in the Supreme Court decision, said that that's like the censorship apparatus that they had back in the day in England, where you had to get permission of the sovereign in order to publish. And you could be punished if you didn't. And that was enough like the classic prior restraint so that it should be considered a prior restraint. And Chief Justice Hughes announced, based on his historical research, that the chief purpose of the First Amendment, he said, was to prevent prior restraints on publication. Acknowledging that, therefore, prior restraints are not generally permitted, the question is, can you ever have a prior restraint? Does that mean that no prior restraint can properly be granted? And Chief Justice Hughes stopped short of saying no prior restraint can be granted, no absolute ban on prior restraint, and he cited Justice Oliver Wendell Holmes' opinion back in 1919 in the Schenck case, one of those World War I subversive cases, in which Holmes had said that when a nation is at war, many things that can be okay in time of peace will not be tolerated. And Hughes added that there's no question that the government can prevent actual obstruction to its recruiting service, that is the military draft, or the publication, this sounds a little quaint now, or the publication of the sailing dates of transports. Troops are being sent to Europe to fight, when are they going to be there, or the number or location of troops, which would give useful information to the enemy. There's no question that those kinds of things can be enjoined. The publication of that kind of information can be enjoined, along with obscenity, incitement to acts of violence, and similar examples. And what Chief Justice Hughes did was give us a laundry list of exceptions to the rule against prior restraint. These kinds of things could be subjected to prior restraint in an exceptional case. What he didn't give us is a test or a standard or a rule for judging whether some future order by the government not to publish something is constitutional. He just gave us a list of examples. He did not elaborate a test that could be applied in future cases. The part of the reasoning that Chief Justice Hughes used in the case, the quote in the reader from the decision about how governments become so much more complex, the opportunities for malfeasance and corruption have multiplied. This could be today, no? Crime has grown to most serious proportions and so on. And you got to look out for unfaithful officials who don't do a good job. And there's a need for a vigilant and courageous press, especially in the big cities. And when that decision came down, Colonel McCormick embraced those words, and he had them carved in marble in the lobby of the Chicago Tribune building in downtown Chicago. They're still there, I've seen them. So Chief Justice Hughes struck a strong blow against the validity of any prior restraint in his decision, but it was a squeaker of a decision. It was a 5-4 vote. And the dissent was written by Justice Pierce Butler, who happened to come from Minnesota and knew the actors in the case, knew of the kinds of journalism, so-called journalism, that Neer had engaged in, and he was highly upset that the court had disabled the state of Minnesota from dealing with this scourge, with this nuisance of these scandal-mongering newspapers. And one of his points was, this is not a prior restraint. This is not like what they used to do in England. Neer wasn't required to submit his copy to the government censor ahead of time. Moreover, Neer has a track record. He's published 9 consecutive issues. Every Saturday he comes out with another issue, and they're all just like this, loaded with malicious and scandalous material. It's not a prior restraint, Butler says in dissent, to say that enough, we know what you do, don't do it anymore. And thought that the majority had misread Blackstone and what the English history had been, and so on. But Butler was on the losing end of that. Hughes's analysis that the practical effect of this law was like a prior restraint was good enough. And then Butler, to make it clear how dramatic the majority decision was in striking down the state law, quoted what Neer had argued to the Supreme Court. The majority didn't do this. Neer had argued that Minnesota says that the Constitution was never intended to be a shield from malice, scandal, and defamation when untrue, or published with bad motives, or for unjustifiable ends. Neer's argument was that the contrary is true. Every person does have a constitutional right to publish malicious, scandalous, and defamatory matter, though untrue, and with bad motives, and for unjustifiable ends, in the first instance, comma, though he is subject to responsibility, therefore, afterwards. That's what Neer argued. That's what the court decided. That's the thrust of the rule against prior restraint. We do have the right to say what we want to say in the first